Okay, members, everyone, let's try to get moving today. I know state lasted a minute or two longer than trying to get settled. Welcome to Civil Justice Full. Madam Clerk, if you go ahead and call the roll.
Representatives Bricken, Bolso, Capley, Eldridge, Gant, Garrett, Grills, Harris, Lamberth, Littleton, Parkinson, Powell, Russell, Stevens, Todd, Vice Chairman Jernigan, Chairman Farmer. Mr. Chairman, you have a quorum.
Thank you for that. Members, we have any personal orders, announcements, comments before we get started? I have one. I have a colleague sitting in the audience there, Assistant District Attorney himself, Jeremy Ball. Want to make him welcome today. Thank you for being here, sir. Appreciate all you do for the 4th Judicial District, Jefferson County especially, keeping the law and order straight there. Anyone else? All right, we got a Representative Grills. Chairman Grills, excuse me, you recognize.
Thank you, Chairman Farmer. I want to recognize a good friend of mine, Mr. Doug Robertson. He is from Lake County. That's about as far west as you can be and still be in Tennessee. He's a Republican Party chairperson there and been a longtime supporter and friend of mine. So y'all make him feel welcome.
Welcome, sir. And Representative Bricken, you recognize, sir.
Back in the back seat there is a former state representative that I always have admired, and I think we all enjoyed working with him, Martin Daniels. So if Martin would stand up and be recognized.
Yeah, Representative Daniel, we appreciate you being here. You're hiding back there like a ninja. Just eased in on us, but we appreciate you being here. Anyone else? We good? Okay. All right. Let's get started. We have item 1, members, House Bill 2119 by Chairman Faison. You got a motion second, sir. It looks like you have an amendment 14194 there.
Yes, sir.
Would you like to put that on?
Yes, sir.
All right, members. We got a motion. We got a second. And we want to go ahead and put that on, members. Any objection? Seeing none. All those in favor of adopting House Amendment 14194, say aye. Aye. Opposed, say no. Ayes have it. All right. Amendments adopted. We're on the bill. You're recognized.
Thank you, Mr. Chairman, committee. Very good to be with y'all. Hope you're doing wonderful, enjoying this beautiful weather today, and hope y'all shine down favorably on this wonderful piece of legislation that I have before you today. In the state of Tennessee, eminent domain has been historically used to do some really good things, and there's been times that I believe eminent domain has been abused. When I look at our current TCA, eminent domain is wide open. And basically, the condemning authority has an unbelievable amount of leeway in deciding if they want to condemn your property and take it from you. I believe that property rights are pretty sacred. I would argue that our Constitution gives us more protections for our property than just about anything else that we find in the Bill of Rights. So with that, with y'all's indulgence and with the state's indulgence, I would like to put some guardrails on how eminent domain takes place. We've come up with 4 things. This actually came to me from a constituent, which I love when the legislature brings in a bill from somebody at home. The chairman of this committee and myself, we have constituents who've asked us to do this. This is a genesis of their idea. So these are the 4 things that the guardrails that I'd like to put on before a condemner takes a piece of property by the use of eminent domain. The first one is that it is required for public use. There is already in the TCA what it means to be public use. And so we're saying that if you take it for eminent domain, it has to be number 1 for public use. Number 2, this is very important, that the condemner has a plan and a schedule to complete whatever they're taking it for. We have found, as I got into this, started looking around, there are times that a condemner, a city, municipality has taken land, and 10, 15 years later, they still haven't done what they were going to do. So we're saying you have to have a plan, what you're going to do with it, and then a timetable. Number 3, that they actually have the ability to pay for whatever plan that they're going to do in the time that they're going to do it. it's fine to have great ideas, but you should be able to back up your plan. If you're going to use eminent domain to take a person's property, then you should be able to say, first of all, it's public use. What are you going to do with it? How are you going to get it done? And then how are you going to pay for it? And then finally, we want you to first look to see if there is some adjacent or property near that area that is also available for public use or that could be potentially for sale. And with that, I renew my motion. Can't do that.
Thank you, Chairman Faison. Members,
No,
we have any
this committee.
questions for Chairman Faison? Representative Powell, you're recognized, sir.
Thank you, Mr. Chairman. So outside of the legislature, I work in real estate, and we hear a lot and know a lot about eminent domain. One quick question. Some of our road projects that involve TDOT, or it might involve our cities, I've been frustrated because the right-of-way acquisition phase has taken so long, and I get it why that is, because there is a taking of those people's property and they're compensated. There's a whole process for that. But oftentimes that right-of-way phase takes place before the actual funding of the construction takes place. So under that scenario, just making sure this would no way would impact that. Is that correct?
Chairman.
Thank you. And Dr. Powell, to alleviate those concerns, this bill doesn't have impact on infrastructure such as roads or gas or utilities. It doesn't have any impact on that.
Representative Powell.
And one follow-up to that. Does that include rail?
Chairman.
No, sir. No, I mean, rail is included in infrastructure.
Okay, thank you.
Transportation, yeah.
Thank you.
Very good. Representative Eldridge, you're recognized.
Thank you, Mr. Chairman. And this is more of a statement than it is a question for the sponsor or anything like that. And just so the committee knows, this came out of a county, or well, actually the city next to Hamlin County, where the city was going to take property that a hospital owned to build a recreation center on. Now, the hospital, in my mind, had the forethought to purchase the property for future use down the road for the benefit of that community. And my understanding is there was property across the road that was available for sale, which, to me, just the ideal of taking it for recreational purposes from the hospital, let alone an individual property owner. And we all know the area, I'm familiar with the area down there. There's a lot of property for sale, and to the ideal of building a rec center, I don't have a problem with, but there was a property owner stepped up and donated property for the rec center to kind of put an end to that. And we really appreciate him doing that. But that was where this came from. The county government did a resolution opposing that move by the city. So I just wanted to make that statement there.
And that's an accurate statement. And thank you for that, Representative Eldridge. Representative Garrett, you're recognized, sir.
Thank you, Mr. Chairman. Mr. Chairman, thank you for bringing this piece of legislation. I've got just a couple clarifying questions, I think. In the bill, I assume this statute's going to be applicable if the condemner has filed a lawsuit, right?
Chairman.
Thank you, Mr. Chair. You're going to have to forgive me. I'm not, if the condemner's filed a lawsuit against the property owner?
Yes. For an action, because the proving what you're setting up to make sure you condemn it by preponderance of the evidence is
Right.
There's a lawsuit filed for that level of proof that you've got to establish under your section A 1 through 4.
Correct.
So this wouldn't affect if a landowner is either agreeing with the condemner and they got a fair price, et cetera, under our laws of this type, that's not going to affect any type of agreement.
Chairman Faison.
Thank you, Mr. Chair. And Dr. Garrett, you're correct.
Okay.
This would not have any impact on that. If the owner of the property is completely willing and ready to sell, this wouldn't have anything to do with it.
Representative Garrett?
One final clarification, just so, this creates a defense in a lawsuit that you've got to prove necessity, right?
Correct.
So if you disagree with it and you raise that affirmative defense, I believe is what you're creating under this statute, that says, hey, you got to tell us these 4 reasons and prove those by preponderance of evidence. The only thing that I see a little bit, under 3, that it says the condemner has access to the funding. I would assume that you mean if it's the city of Hendersonville, which is one of the cities in my district, that access can mean several things. Do you mean or intend that they've actually budgeted for that item and that money has been budgeted and ready to be spent? Because I believe that's a little bit different than just having access to it. So I just want to make sure I'm clear on what that means.
Chairman Faison?
Thank you, Mr. Chair. And Dr. Garrett, from my understanding, dealing with legal, when we drafted this language, it means that they have the ability to either borrow to pay for it, or they do have the funding, either or. They have the capability of paying for their plan through either borrowing or have already appropriated the money for it.
Okay. All right. Thank you very much.
Very good. Thank you. Hey, Leader Lambert, you recognize, sir.
Thank you, Mr. Chairman. Mr. Chairman, I want to thank you for recognizing Dr. Garrett and Doctors Bulso, Stevens, Farmers, and myself. We rarely get the recognition of having a Juris Doctorate, but today you have done so. And I just wanted to say we appreciate that. I mean, these other medical doctorates, they get that recognition on a regular basis, but the Juris Doctorate never truly gets recognized or any type of love the way our medical doctorate brethren do. So, we appreciate that. Thank you, Chairman.
And thank you, Leader Lambert. Chairman Faison?
Thank you, Dr. Chairman. I would say that if you're smart enough to be on this full committee, you probably deserve a PhD.
Well,
Question on the bill.
I see objection. I see objection from Representative Parkinson there about that. So, Representative Parkinson, you recognize. You want to be recognized?
Thank you, Mr. Chair. I was just going to comment on the loose tossing to and fro of the title doctor in this committee by the sponsor of the bill. Thank you, Mr. Chair.
Thank you. Members, any additional comments or questions for Chairman Faison before we vote? Are we ready? Any objection? Seeing none. We're voting to send House Bill 2119 as amended to calendar rules. All in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on. Thank you. Brings to item 2, House Bill 2183 by Chairman White. Members, we don't have an amendment traveling with this, Chairman White, so you're probably recognized.
Thank you, Chairman and Committee. This particular bill before you is titled Safe Baby Courts. In 2017, I carried this bill at the behest of Senator Farrell Hale, where we established 5 safe baby courts throughout the state at the time. Now, the purpose of safe baby courts is to reduce the incidence of child abuse, neglect, and endangerment on the 0 to 3 population to get them into a home of permanency as quick as we can. And since then, we have continually expanded the program, and there are now 13 fully operational safe baby courts. All we're doing in this bill is we want to extend, keep the program to remain in place without a sunset, so we can continue providing resources for increased stability in our Tennessee homes for that 0 to 3 critical population. And with that, I renew my motion.
Thank you for that explanation, Chairman White. Members, do we have any comments or questions for Chairman White? I had one member on there, Representative Bricken. If you may, I have Leader Lambert. You recognize, sir. Thank you.
Question on the bill.
Yeah. All right. Any objection? Seeing none, members are voting to send House Bill 2183 to Finance, Ways, and Means. All in favor say aye. Aye. Opposed say no. Ayes have it.
Very
Thank you.
appreciated. Thank you.
That brings us to item 3, members, House Bill 2067 by Representative Butler. Sir, you have a motion in a second, and I see 2 amendments here. Do we need to adopt both of those, or?
Thank you, Chairman. Well, I'll leave that up to you. It's your committee.
Well, I need to know whether you want to move them first.
Yes, sir.
All right. So I have House Amendment 13710.
That is correct.
Is that what sort of adjustment does that make to the bill?
That one, let me make sure before I answer the question incorrectly.
Okay.
That one rewrites the bill.
Okay, it does. Members, we want to go ahead and adopt that amendment. Any objection? Seeing none, got a motion and a second. We're voting to adopt House Amendment 13710 to House Bill 2067. All in favor say aye. Aye. Opposed say no. Ayes have it. Amendments on. And Representative Butler, we also have House Amendment 14471. You got a motion, second. Members, we want to go ahead and adopt that amendment. Any objection? Seeing none, voting to adopt House Amendment 14471 to House Bill 2067. All in favor, say aye. Aye. Opposed, no. Ayes have it. Now we're back on the bill as amended. You're recognized, sir.
Thank you, Chairman and committee. This legislation is to create, as it's amended, creates a grant program for counties to apply to the state for grant money to put in a safe haven baby box. They would be required to pick the location, ensure that the location complies with all the requirements, and then they would apply for the grant. The state would issue the grant money back, and then the county would be responsible for implementing and installing that box. And with that, I renew my motion and answer any questions.
Very good. And thank you for that explanation, members. And without objection, we're going to roll those two House amendments into one without objection. Members have any questions or comments for Representative Butler? Seeing none, are we ready to vote? Looks like we are. Voting to send House Bill 2067 as amended to Finance, Ways and Means. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, committee.
You want to be recorded as a no, see the clerk. Brings us to item 4, House Bill 1906 by Representative McCalman. So you got a motion in a second, and I see House Amendment 13397. Is that an amendment you'd like to adopt?
Yes, sir.
And you've got a motion and second on that. Does that amendment rewrite the bill?
No, sir. Just changes one line, sir.
So it's just
Correct, sir.
okay. All right, members, want to go ahead and adopt it? Any objection? Looks like we do. We're going to adopt House Amendment 13397, House Bill 1906. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're recognized.
Thank you, Chairman. Members, it's a pretty simple bill. What this does is extend the statute of limitation for victims of human trafficking for civil suit from 15 years to 30 years. Oftentimes, victims of these horrific crimes don't come to terms with this trauma for decades after it has occurred, and this just extends the opportunity to go back and claim recompense against their attackers. And with that, I stand ready for questions.
Very good. Members, any questions or comments for Representative McCalman? Seeing none? Are we ready to vote? Looks like we are. Any objection to voting to send House Bill 1906 as amended to calendar rules? All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Chairman and committee.
Thank you, sir. Now it brings us to item 5, House Bill 1676 by Chair Lady Littleton. And you've got a motion and second, ma'am. You're recognized.
Thank you, Mr. Chairman, and it does have an amendment on it, 13967.
Very good. You've got a motion and a second. And any objection to voting to adopt that House amendment, members? Seeing none, we're voting to adopt House Amendment 13967 to House Bill 1676. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. House Bill 1676 is an administration bill for the Department of Children's Services. The bill as amended helps DCS keep children safe by cleaning up several parts of the code related to different grounds for termination of parental rights and other related provisions. This bill will refocus the definition of severe child abuse to look at the the status of the child and the injuries the child suffered, as opposed to focusing on the perpetrator. This bill would also ensure a child would not be placed in a home where a parent or individual cannot be excluded as a perpetrator of severe child abuse. Additionally, the bill expands the definition of severe child abuse by including various human trafficking related offenses. This change helps the department serve a broader population of human trafficking victims. Lastly, the bill adds the definition for token child support, stating that child support is presumed token if it is less than the minimum established by the Department of Human Services guidelines. Parents and or guardians may refute the presumption of the preponderance, the evidence of the standard. I ask for support for this bill.
Very good, and thank you for that explanation. And members, I do have two folks that have given notice to testify. So we're going to end up going out of session at some point in time. We want to go ahead and ask Chair Lady Littleton questions now, or do we want to wait until our guests testify? All right. With that, without objection, we'll go out of session. We're going to hear from Connie Reguli. Connie, ma'am, if you go ahead and take a seat there, and then Mr. Farley, I'll get to you here in just a moment. Connie, you'll have, or Ms. Reguli, excuse me, you'll have 3 minutes. Just be sure the red light's on, your microphone there, and just be sure it's placed properly in front of your mouth so we can hear you and it picks you up, and you'll have 3 minutes. Thank you.
Good morning, Chairman and members of the committee. I'm Connie Regularly of Williamson County. Most of you have met me, but for the record, I will say that I have been buried in the chaos of Department of Children's Services since its inception in 1995. I have followed the budget, the reports, the news articles, and worked with hundreds of families and victims. I gain nothing by being here today. This is why I do this. I'd like you to meet my granddaughter. I want her and your grandchildren to have a future in Tennessee where they can live free and raise their families without fear of the government. I also have a grassroots organization of over 19,000 families working to change the child welfare system. I will give you 2 reasons to vote no on this bill, even though I have many. First, it reverses the burden of proof by saying that the court must exclude a parent as a perpetrator by clear and convincing evidence before they can regain custody. This is a clear constitutional violation. The Supreme Courts of the United States and Tennessee have recognized that parents have a constitutional right to parent, and the court must find a parent unfit by clear and convincing evidence for the government to interfere with those parental rights. Full stop. DCS will say to you today that this is not unconstitutional because the court must first find that the child has been abused or neglected by clear and convincing evidence, then has to exclude the parent. This is like saying the court can find a bank was robbed, and if you happen to be anywhere near the bank that day, the court has to exclude you as the robber or you go to jail. Second, this bill allows the state to bring in an expert paid by the state to predict some future psychological event that may happen because of your child's exposure to trauma or neglect. They do use this tactic, and I have seen it. However, what is ignored is that separating a child from its home of origin causes severe long-term anxiety and often depression. It forms the basis of attachment disorder, which is well settled as a precursor of psychopathology. I promise you that DCS will embed itself in using this law aggressively as we face more challenges raising our children. As I said, I have nothing to gain. I could rest my head at my farm in the country, but I have a responsibility, and we have a responsibility to make her and your grandchildren's life better. DCS staff are paid by the taxpayers to strip away parental rights, a far departure from what the public policy was in 1995. It was intended to be remedial and support reunification. This year, Commissioner Quinn asked for the largest increase in DCS funding ever. The public records show that those public funds are now being directed to big bonuses for the executive bureaucrats. I ask you to vote no.
And thank you, Miss Regularly. And I should have recognized the little miss sitting beside you. What's your granddaughter's name?
I'm telling you.
Yeah, you'd like to introduce yourself to the committee? We appreciate you being
Nuke
here.
Regularly.
I'm sorry, what?
Nuke Regularly.
Good. Well, thank you for being here. You have anything you'd like to say? Okay. Well, we appreciate you being here. It means a lot. Members, who have any questions for Ms. Regularly? Any questions or comments? Representative Parkinson, you recognize.
Thank you, Mr. Chair. I have raised some concern to the team at DCS about the token child support and the fact that the presumption was against the parent, and with it being so serious, with this bill being as serious as it is in terminating parental rights, that brought up a real concern of mine, because it's making it easier for you to terminate the parental rights of a parent who may not have been reaching the threshold of what Department of Human Services says is the minimal child support that should be paid, but they've been making an effort, and I would think that the majority of the demographics of the individuals that's in these situations are people from probably close to the poverty line, and can you speak to that concern?
Yes,
Am I
sir.
off base, or am I?
No, sir, you're right on. And honestly, I don't think parental rights should ever be terminated on money issue. I've worked with too many families. So many of the families, 1 in 5 children in Tennessee live below the poverty line. Those are most of the families that end up being in DCS. These families, while their children are in DCS custody, they're required to jump through all kinds of hoop, attend classes, go to meetings, go to administrative hearings. Some of them have even lost their jobs because of those demands. I don't think a person should ever leave their parental rights over money.
Thank you, ma'am.
Thank you. All right. That's all I have on the list. Thank you, Ms. Regularly.
Thank you.
And Ms. Regularly. Appreciate y'all coming. Mr. Farley, you're recognized, sir. If you take your seat. And Miss Farley.
Thank
you. Okay. There you go.
Can you hear me?
Yeah, yes,
You're
yes. we
too
can.
far away, so I'm going to rely on my beautiful wife of 15 years to tell me what you're saying. Whenever you're ready, I'm.
Okay, just let Mr. Farley know that we're ready. He'll have 3 minutes, and we'll begin. Time will begin when he starts speaking.
Ladies and gentlemen of the committee, my name is Chad Farley, and I am a resident of Morgan County. I stand or sit before you today, and not just as an advocate for family rights, but as someone who has experienced firsthand the devastating impact of an aggressive state agency. It is difficult for me to share my thoughts on this legislation without recalling the terrorizing moments when I stood outside my home, surrounded by local law enforcement, while they tramped inside and swept away my 10-year-old child. All while my wife suffered from acute psychosis and was involuntarily committed with her first severe battle of COVID. She's now on 4, all diagnosed by Johns Hopkins. My son is now home, but he, after 11 months of a lengthy battle in the court system and a lot of money, but he is not the same. He came home psychologically damaged, anxious, and terrified that this could happen again. A child that was once strong, curious, has now secluded himself and is afraid to be away from our home. The case against me and my wife expanded out of the false allegations made by a scorned ex over a troubled teenager that suddenly happened. Instead of attempting to remedy that issue with the other parents, the state used those allegations to cause irreparable harm to our family and prolonged separation from my daughter's mother. In that case, DCS attempted to predict a future psychological event in spite of ample evidence that the child's past trauma was caused by a hostile divorce and custody battle. This law reverses the burden of proof and puts parents in a place of trying to prove their innocence instead of requiring the state to prove that a parent abused or neglected their child. Another section of this law allows the state to use an expert to predict that there will be some sort of psychological disorder in the future. And to end, I am not just a parent. I am a veteran who served my country honorably to protect these rights that you guys are up here trying to uphold. I left my service with long life injuries. The Department of Children's Service has used that against my family. I ask that you reject this law as written and strive to do better for our Tennessee families. Thank you.
And thank you, Mr. Farley. That was almost perfect timing there. Members who have any questions, I have Representative Parkinson on the list. You're recognized.
Thank you. I'm trying.
Thank you, Mr. Chairman. I was actually going to be out of order. We have one of our general sessions judges to walk into the building, and if she'll stand, Judge Danielle Mitchell, if you'll stand, and we'll make her feel welcome. We appreciate it. And with her is Attorney Taylor Batchelor. If you'll stand also, make them feel welcome. Thank you. Thank you, Mr. Chair.
And thank you. And ladies, we appreciate you all being here as well. Members, any questions for Mr. Farley? Chairman Russell, you're recognized.
Thank you, Mr. Chairman. Mr. Farley, I just want to say thank you for your service and thank you for your testimony today.
Members, anyone else? I don't have anyone else on my list. All right. And thank you, Mr. Farley, for being here. We're going to go back into session without objection. Members have any questions for Chair Lady Littleton? We ready to vote? Any objection to voting? Seeing none, looks like we're ready to vote. Send House Bill 1676 as amended to calendar and rules. All those in favor say aye.
Aye.
Opposed say no. Ayes have it. Bill moves on. You want to record it as a no, see the clerk. Brings us to item 6, House Bill 1830, also by Chair Lady Littleton. All right, you've got a proper motion and second. You're recognized, ma'am.
Thank you, Mr. Chairman. This bill is asking for a judge for the 23rd Judicial District. I think we're hearing this across the state. Judge Wolf, he testified in our subcommittee the other day, and he says that there are so many criminal cases that he can't get to the civil cases. So if you're looking for a divorce or anything that's civil, you're having to wait for months and months to before your case is heard. So with that, I just ask for support for House Bill 1830.
Very good. All right, members, any questions for Chair Lady Littleton? I have Representative Powell on the list. You recognized? All right, question's been called. Any objection? Seeing none, looks like we're ready to vote. Send House Bill 1830 to Finance, Ways and Means. All in favor, say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Chairman and Committee.
And thank you. Members, that's all we have for today. We have anything else before we adjourn? Any objection to motion for adjourn? All right. We'll see y'all next week.